I'm delighted to introduce our next speaker in this panel. And this panel really is, before coffee and after coffee, is really about exploring international human rights law and the significance and legal status of the UN Convention on the Rights of Persons with Disabilities. Now, you'll see in your programme that my colleague, Professor Gerard Quinn, was scheduled to chair this session and the session in the evening time. Unfortunately, Gerard was called away in some pressing matters, but he will be with us this evening, hopefully, and later in the week. So I'm delighted to introduce my colleague, Dr. Ciara Smyth, from the School of Law here at NUI Galway, who is going to give a talk on international human rights law, the ABCs of using and interpreting a treaty and international human rights law. Just to say a little bit about Ciara before she starts, Ciara lectures public international law and the international protection of human rights law in the School of Law, and she also teaches in our Irish Centre for Human Rights a course on refugee law. Ciara is an award-winning human rights lawyer. She was awarded the Max van der Stoel Award for her PhD, which she completed in the University of Leiden in 2013. Ciara is widely published in the field of immigration and asylum law and has a special interest in the European asylum system and children. So I'll hand you over to Ciara, who's going to give us an introduction to the ABCs of interpreting international human rights law. Thank you.
Thanks very much, and thanks to Charles for inviting me today. What Charles left out of that impressive introduction is that I'm really not a disability lawyer at all, so I'm learning a lot this morning. The perspective that I'm hopefully bringing this morning is one of public international law, and to try and situate international human rights law and the CRPD within its wider public international law framework. And maybe to address a little some of the concerns or some of the frustrations that I think were evident in the panellists this morning regarding perhaps the unfulfilled promise of international human rights law. So I think if we can put the CRPD and international human rights law in its public international law context, we can understand a little more how some of these frustrations come about and how better perhaps to realise the promise of human rights law. So I'm going to talk about sort of international law, international treaties, the CRPD, and a little bit about the function of human rights law. So I'm going to start by giving a few words on international treaties. Treaties like the CRPD are one way for states to make international law. There are various other ways, for example, international law is made through custom, through what states actually do, the practice that states have on a day-to-day basis. But sometimes states come together deliberately to form a treaty, and in that sense, a treaty is a little bit like a contract between states. States negotiate, sign and ratify a treaty, or they may accede to a treaty if they haven't been involved in negotiating it. Treaties are legally binding, and sometimes people don't realise this, people who are not familiar with the world of public international law. Treaties are legally binding on states that have ratified or acceded to them. And at the international level, treaties supersede conflicting domestic law. In other words, if a state has signed and ratified a treaty or acceded to a treaty, it cannot rely on a provision of its internal law as justification for failure to perform the treaty. At the international level, it cannot do that. It's not permissible. And this is a very age-old principle of public international law, and it's laid down in the Vienna Convention on the Law of Treaties, which I'll be speaking about later, but also in some of the oldest case law dating back to the American Civil War. This is a general principle of public international law. So at the international level, international treaties are more important than domestic law and supersede domestic law. Now, there's a separate question, though, which is whether or not a treaty will have domestic effect. In other words, a state can sign and ratify a treaty at the international level, it can be bound by a treaty at the international level, but whether or not that treaty has effect within the domestic legal system, to the extent that individuals can rely on it before domestic courts, will often come down to a question of, well, what type of state is it? Is it a monist state that recognises no distinction between international law and domestic law, in which case international law has full domestic effect? Or is it, like Ireland, a dualist state, where international law is regarded as being a little bit like a foreign currency that you have to translate or convert into a form that's recognisable? And this is the kind of dualism we have in Ireland. So if a state is dualist like Ireland is, a treaty has to be incorporated into domestic law before it has any domestic effect. Of course, the problem with the CRPD in Ireland is not yet one of incorporation, it's the fact that we haven't actually ratified it yet. But presuming that we do at some point ratify the CRPD, the problem will then turn to one of incorporation. Now, a few words on international law. International law is the law that governs the relations between states. So when we think about international law, typical domains of international law would be, for example, international trade law, civil aviation, international diplomacy, where one or more states, well, it's always one or more states, come together bilaterally or multilaterally to agree on something that's in all their common interests. So if you think about diplomatic law, it's in every state's interest that diplomats are treated in a certain way and that they benefit from immunity. So that's generally what public international law is about. Now, international human rights law is a branch of public international law, but it has some unique characteristics. And it's these characteristics, I think, that account for some of the frustrations that were expressed this morning. States agree with each other about how to treat individuals within their jurisdiction. Okay, so that's what essentially what human rights law is about, is states agreeing with each other, not for the purposes of mutual reciprocity at all. So they're not agreeing to get benefits from each other, they're agreeing with each other about how they're going to treat inhabitants within their own territory. Okay? So it's not states that are the rights holders, as is usually the case in public international law. It's individuals that are the rights holders, but it's also individuals that are the victims. And this is again different, because normally in public international law, states are the rights holders and states are the victims of violations, and states assert their own rights. That's not the case when it comes to international human rights law. Therefore, the usual rules of state responsibility don't apply. And when I talk about state responsibility, what I mean is, normally in international law, where there's a violation of public international law, the victim state asserts its rights against the aggressor or the violator state, and a certain procedure pans out. But obviously that doesn't really apply when it comes to international human rights law, because there is no victim state. The victims are victims of the state that has taken on that human rights obligation. So the usual rules of state responsibility don't apply. States delegate then the monitoring and accountability tasks to a centralised body, for example, the European Court of Human Rights or the Committee on the Rights of Persons with Disabilities. This body that states delegate to may or may not have legally binding powers, depending on the terms of the treaty. So, for example, in respect of the European Convention on Human Rights, the European Court of Human Rights is the judicial body. It hands down legally binding judgments, but that's quite rare. That's not very often not the case. In the case of the CRPD, for example, it's the Committee on the Rights of Persons with Disability. The terms of the CRPD do not allow the committee to pass any legally binding measures. So that's another disadvantage. And then another unique feature of international human rights law is this issue, the fact that dualism and failure to incorporate international human rights law treaties into the domestic realm has a much greater negative impact than is usually the case. Because normally at public international law, where you have state versus state and state interests pitted against other state interests, it doesn't matter that individuals can't rely on international law at the domestic level, because it's not individuals that are affected, it's states. Okay? But obviously, again, going back to the beneficiaries of international human rights law, if there's no mechanism for those individuals at the domestic level to assert their rights, then they're largely voiceless. Okay, now just to sort of contextualise the CRPD within the plethora of UN human rights treaties that we have, most people will be aware of this long list of now 9 core international human rights treaties that have been developed over the past 60 years or so. And many of these will be very familiar to you, and the CRPD is one of the later additions to this sort of cross-section of different treaties. How does this system work? Well, if that wasn't complicated enough with 9 different international human rights treaties, it's actually an awful lot more complicated than that. So each treaty has a treaty monitoring body, and the treaty monitoring bodies carry out a number of different important functions as follows. States are required to report under the treaty periodically, normally after the first year and thereafter every couple of years. They're obliged to report on the progress or lack of progress that they've made in implementing the treaty. Of course, NGOs and intergovernmental organisations can make shadow reports, and then the committee will take all the information together and will issue concluding observations. And concluding observations are a way for the relevant committee to say to the state, well done in areas X, Y and Z, not so good in areas A, B and C, must work harder. And it's a dialogue, essentially. Now, committees also issue concluding observations on the basis of their experience in receiving states' reports. They identify various thematic issues that crop up again and again, or misunderstandings of certain rights, and they issue concluding observations, and indeed the CRPD has issued 4 concluding observations to date, I think, and there's a 5th one on the way. Am I right about that? There's also other ways in which the committee can do its normative work and try and get states to comply with norms, and this would include the inquiry procedure, which you have under the CRPD, under the optional protocol, preventive mechanisms such as having a focal point within government or a national coordination mechanism, the individual complaints procedure, whereby an individual or somebody who's being represented by an NGO, say, can make a complaint if they can show that they have a victim status, if they can show that they have been a victim of a violation of the convention. Now, none of the above jurisprudence is legally binding, so we're in the realm of what we call in public international law soft law. Okay, it's not legally binding per se, but it is of high persuasive significance and indeed can become part over time of customary international law, and indeed of treaty law. That's a point I'll come back to in a moment. Okay, so let's look at the UN treaty system in larger context then. So we have 9 treaties, 9 treaty monitoring bodies doing all that work that I've just outlined, but that's just one small piece of a much larger human rights jigsaw that's operating at the UN and regional levels. So also within the UN system, we have the more political UN Human Rights Council and its thematic mechanism, and we were so privileged this morning to hear from the UN Special Rapporteur on the right to health, and that is one of those thematic mechanisms of the UN Human Rights Council. We have the UN organs like the General Assembly and the Security Council making hard and soft law, so General Assembly resolutions are legally binding. Sometimes they have human rights content. General Assembly resolutions, the Security Council resolutions are legally binding. General Assembly resolutions are non-legally binding per se, but again, high persuasive and moral authority, and the General Assembly often pronounces on human rights related issues. You have all the plethora of UN agencies all mainstreaming human rights into the work that they do, or at least they should be mainstreaming it. Then if we add regional systems into the mix, like the European Court and Convention of Human Rights, and other overlapping branches of international law, because this is an era of globalization where no area of law, whether it's disability law or anything else, is entirely self-contained anymore, because everything is overlapping. So you have overlapping branches of international law, like international refugee law and international criminal law. And I was interested to note that the Committee on the Rights of Persons with Disabilities has joined together with the Committee for Migrant Workers to issue a statement on the needs of refugees and persons on the move with psychosocial disabilities. So there's other overlapping branches of international law that impact on the human rights regime, that may not be strictly speaking human rights law, but that still have an impact. And finally, if we add domestic policy makers and courts, they're very important because they form customary international law, that other main source of public international law that I referred to earlier. So if you take all these different pieces of the international law jigsaw and you put it together, what do you get? You get lots of potential for norms to clash, okay? And a kind of prime example of this, and I know it's something that's going to be discussed in later panels, both today and in future days, is, for example, the CRPD versus the ECHR, particularly when it comes to the right to liberty and involuntary detention. So this raises an important but vexed question, which is how should treaties be interpreted and how should treaties be reconciled, and indeed can treaties be reconciled? Well, we do have some guidance, although it's limited in this regard, and it's the Vienna Convention on the Law of Treaties from 1969. This talks about ideally the way in which different treaties, including human rights treaties, should be interpreted. And Article 31 is the key provision of the Vienna Convention on the Law of Treaties, and it advocates what we call a harmonious or a schematic interpretation of conventions, which is to say that a convention, any convention, should be interpreted in good faith. That's the first thing, in good faith. An ordinary meaning should be given to the terms in their context, in the light of the object and purpose of the treaty. Okay, so the ordinary meaning is to be given to the terms of the treaty in the context of the treaty, and context would include the preamble and any annexes, any protocols, and subsequent practice. So this would include practice that's been developed through the mechanism of the Committee for the Rights of Persons with Disabilities. So that's the harmonious sort of schematic interpretation. The travaux préparatoires, or the preparatory documents, are only a supplementary means of interpretation because all treaties are meant to be living instruments and therefore should not be interpreted from a historical perspective simply in light of what the drafters intended, but rather they should be interpreted in an evolutive manner. Now, there is one small provision of the Vienna Convention on the Law of Treaties which deals with what happens when you have successive treaties governing the same subject matter. Now, this pertains mainly, again, to the interstate context. So if you have two or more states who agree on an international environmental law about disposing of hazardous waste, let's just say, and they agree on something in the 1980s, and now in 2017 they've agreed on something entirely new and different in light of modern conditions. Obviously, the later one supersedes the earlier one. That makes sense. That's not that helpful, though, when you're not looking at the interstate context, when you're looking at individuals trying to get states, perhaps, to interpret one treaty, let's imagine the European Convention on Human Rights, in the light of a later human rights treaty, say the CRPD. So, should we be worried about divergence? Should our goal be to eliminate divergence and try to always attain clarity and consistency and harmony between international treaties? Well, certainly within the UN system that we looked at earlier, they're the 9 core treaties that we looked at earlier, there is an argument for an overall schematic approach, okay? Because if the different treaty monitoring bodies are not paying attention to what each other are doing, then there's going to be divergence, there's going to be chaos, and there's going to be a lack of legal certainty, and there's going to be an undermining of the credibility of the different, the various committees. So there is an argument for an overall schematic approach in the context of the UN treaty system. But regional systems are more self-contained. It's harder to argue that judges of the European Court of Human Rights should interpret the European Convention on Human Rights in the light of the CRPD, because that's not what judges of the ECHR are tasked to do. Now, evolutive interpretation within the European Court of Human Rights is, of course, possible, and very often judges of the European Court of Human Rights will show an interest in and a knowledge about different areas of law that impact on what they're doing. However, there are limits to what judges of the European Court of Human Rights can do. There are textual limits, for example. So if you read Article 5.1e of the European Convention on Human Rights, it's very different from Article 14 of the CRPD. So there are textual limits. Sometimes there may be a lack of European consensus, and I think we've heard that here this morning, that what states actually do in practice is quite different from the norms that are laid down, for example, in the CRPD. So there might be a lack of European consensus about involuntary detention, for example. And where there's a lack of consensus, the European Court of Human Rights has developed this doctrine of the margin of appreciation, where basically it leaves it to states to decide how they're going to interpret a particular provision. So I suppose my message is that divergence, it's not always going to be possible within the human rights framework to eliminate divergence. And that leads to the question, is divergence necessarily bad? And I suppose this depends on your view of the role of human rights law. And this, I suppose, leads me back to the discussion, the frustrations that were articulated by some of the panellists this morning. What is the role of human rights law? I think anybody who is a human rights advocate would think, and I know I do, that we're all fighting the good fight, and that human rights law is about stating what should be. Okay, it's a normative. It's a normative function. It's a normative struggle, and we're trying to articulate an ideal and trying to get to that ideal. But let's be more pragmatic. What is it that human rights actually does? Okay, and I think the answer to this question is quite revelatory. I read an interesting article in the Human Rights Quarterly recently by Dancy and Farris, nothing to do with the CRPD, but they gave me some insight, I suppose, into this question. If you're an international legalist, okay, you think then that law constrains power. And we had power that was mentioned a few times in our preceding panel. Law constrains power, and when international law is created, states obey it. Okay? So the word is law. It's a little bit like the gospel, the word is law. If you believe this, okay, if you believe that the act of writing down rights and articulating rights and getting states to agree to those rights, if you agree that that's what it's about, then divergence becomes a battleground, because divergence must be reconciled, and the group that wins the word, and they win out on meaning, okay? And it's that meaning that states will follow. Now, I don't think probably anyone here is naive enough to believe that this is what human rights law is doing, because we know, and we're hearing it often enough, particularly in the counter-terrorism context, that human rights law is in retreat, because we have lots of human rights law, but we don't see much evidence on the ground of it actually being implemented. So I don't think anybody is really an international legalist in that sense. So do we then believe in international coercion? Do we believe that when international law is created, states obey it if they are made to obey it? Okay, this is a little bit like the variation of you'll eat it and you'll like it. That if you can coerce states into implementing international law, well, that's the job done in a sense. Now, there are no coercive mechanisms available at public international law, okay? We have an anarchic system. There is no hierarchy. There's no international police system out there. We don't even have a parliament. There is no court with compulsory jurisdiction over these issues. There is no coercive mechanism. So when I talk about coercion, I'm talking about soft measures. Measures like using persuasion and acculturation to get states to agree to implement certain norms, okay? And this is really the realm of lobbying and advocacy, and I would say many people in the room probably are advocates of this. Here, if you adopt this view, that the role of human rights law is about sort of batting governments over the head and making it difficult for them not to concede to human rights, or to try and persuade them or make their lives difficult if they don't agree. If that's your view, then divergence is also a bad thing here. Because if you're trying to lobby and advocate, if you have a divergent message, that's not a clear message. And so divergence must be eradicated, and you need a simple, clear message. We need a uniform, harmonious understanding of norms. Okay. But then the last one is my personal favourite, and this is the idea that human rights law is not actually about, getting things necessarily written down because they're going to be achieved just by writing it down. It's not about coercing, using strong or, soft power tactics, states to implement human rights law. It's a dialectic, it's a dialogue. Using a legal language that states themselves adopt, rights claimants form a productive dialect with state structures. So it's like states are being co-opted into the human rights project through this dialectic that exists, that human rights law sets up. We're all using the same language. We're co-opting states to use. We're borrowing, you might say, the language that states have adopted and using it almost against states. And it's in this process of dialogue that change happens. This is my personal belief. Here, divergence is not a problem, okay? It's contestation that counts, actually. It's the dialogue about what are the norms. It's the fact that there are potentially diverse norms. It's the fact that there is maybe one right, but myriad ways of interpreting it. It's the dialogue that matters, dialogue like we're having today. Thank you very much.